All right, y'all, welcome to our session today. Thank you so much for joining us for 10 Things Realtors Need to Know About Estate Planning, presented by Rasmussen Law. As we know, in real estate, we learn something new every day. And while many aspects of the process are great to learn while you're in the middle of it, some things are easier to learn from hearing it from the professionals in advance, because whether it's working with a buyer who's under contract on a listing that's in an estate or working with a seller who's potentially inherited a property in an estate, things can be a little tricky. And so the more we know, the easier it will be for us to guide our clients to success. So that's the purpose of our session for today. Deb, thank you so much for being with us and sharing your knowledge.
Before I bring the slides up, I just want to say, like some of we talked about getting in the middle of a transaction where it's an estate and we're bringing in, there's kind of this crossover. Estate planning is kind of fun that way because we bring in estate planning, estate administration, property law, and sometimes business law is also part of it. So as I'm thinking through this, I'm thinking about your unique role as realtors when you're selling a property and sometimes have some of these concerns. But also, when you have buyers that are coming from a different place, what sort of resources could you share with them? And then also your positioning in your field as someone who has assets and concerns and minor children and things like that. Your real estate business and everything also needs to be top of mind. How is your planning so you don't land into some of these scenarios that you're like, oh, if that's avoidable, I think I would like to avoid that. Okay, I'll go ahead and start sharing my screen and we can just get into it. Did that just share my entire screen? Let's see, we should be right here. Okay.
It shared your entire screen, so we see your desktop as well. There you go. That's what we need.
Okay, is that better? I'm
Yeah.
glad I closed all my client files before we did that. If I go full screen here, can you just tell me if that just looks too huge or if it looks fine?
That looks perfect.
Okay, perfect. All right. So, um, so just a little bit of background about me. This is my cute boyfriend Lars, who I've been married to for 28 years. And I have four children, my daughter Samantha, and then three boys, Joshua, Daniel, and Noah. And so I was kind of a mama bear before I became a lawyer. And so a lot of my approach to working with families is very much informed by being very focused on the outcomes. What happens to a family when they're going through these things? Death and money do lots of weird things to people. And there's a lot of things that are completely avoidable with careful planning. We're going to talk about that. We're going to talk about both, the careful planning, but also, what happens, what if, and also you as a helper, what you can do. These are some of the associations that I am involved with. Brigham Young University was my undergrad. I actually have a degree in linguistics and minors in Chinese and Japanese. Which I don't get to use every day, but I actually got to use Chinese this morning, which was crazy on a consultation. I went to Campbell Law School, which I loved. I'm a member of the J. Reuben Clark Legal Society, which basically fights for religious freedom for all people around the world. I'm a personal family lawyer. I belong to a couple of big bar associations, and this Wealth Counsel designation means that our firm uses the most advanced drafting software that's out there. It's really important to stay on top of the law and things that change. And this, like up to the minute, I can get alerts if something is coming from the General Assembly or something might impact the way things are drafted. We want to stay on top of it. So that's a little bit of who I am. But first, we're going to go into Estate Planning 101. So I want you to understand the fundamentals of protecting your legacy. And I like to start this way because all of us know something. Either we've heard like some sort of crazy story of like something wild that happened in the probate court or some closing that went bad for who knows what reason. And we might understand some of it, but it's kind of like Swiss cheese. Our knowledge is like Swiss cheese. And unfortunately, the law is also like Swiss cheese. We don't have a law for everything. I wish we had a law for every. No, I don't wish we had a law for everything. But that would be easier to find the answers. It just wouldn't be a fun place to live. So I just kind of want to go back to basics for how wills and trusts work. So you have an understanding, and then we can all come at it kind of from this bedrock of understanding. Okay, so there are three ways assets are passed along. They can be jointly owned, and when they're jointly owned, we don't need to know what's in a will or what's written in a trust because we know who the joint owner is, and this is who it goes to. There's also beneficiary designation. So if you have a retirement account or a life insurance policy, Northwestern Mutual or whoever it is isn't going to ask, but what's written in the will? They don't care. It's just whoever's name is in that beneficiary designation. That's who they're going to cut the check to. And then there's the probate court. And something that was kind of shocking to me right before I went to law school, I worked at a real estate firm, a real estate law firm that did closings all day. And I was in charge of the estate planning documents all day long. I thought truly the whole time I lived there that these wills that we were writing as an afterthought to a real estate transaction were going to save families from probate. Okay. I was shocked. I remember where I was sitting in my wills, trust, and estates class when I learned that a will does not save a family from a probate proceeding. It actually triggers the whole thing. And when we're talking about probate, we are talking about a court process with court fees, lawyers, baked in delays, and a new part-time job for whoever is the personal representative, and plenty of chances for conflict in the family. You actually send notices out and you're like, hey, would anybody like to contest this will? Notices go out, people are invited to the probate court. Now, in North Carolina, we also have a way that homes pass along that is a little bit different than in other states, but it still has to go to the probate court at some point if anyone ever wants to sell it. So even though, um, but an owner, a single owner will have that their home go to their beneficiaries, and you think, well, they didn't have any children. Well, guess what? The law is going to find their beneficiaries. But sometimes, if that's not taken care of, it can go to the next generation, the next generation, the next generation. I don't know if you've ever been on any deals like that where the owners have just multiplied with each generation. I've seen court proceedings where they've had to appoint a guardian ad litem for the interest of those owners that could not be found to reserve their interest somewhere and partition the rest. It gets crazy and when people want to pass the buck to the next generation. So we're going to talk a little bit about that, how you can be a hero in that situation. Okay, so it's a huge myth. I hope everybody's on the same page here that a will avoids probate. It does not avoid probate. It triggers the whole process. So this is the big question that people have. Do I need a will or a trust? And we're not going to answer that question today. And frankly, anybody who would answer that question for you without knowing the extent of every single thing that you own. And I'm not just talking about your home, but all the money in your accounts, your retirement accounts, your insurance policies, everything. Until we've inventoried all of that and explained to someone how the law interacts with each of these assets and looked them in the eye and saw how much they cared about that, we can't say if a will is appropriate or a trust is appropriate. But I can say one thing definitively. If you own a home, the only way for your beneficiaries to be able to sell the home, liquidate everything, move on to to the next generation in the best way. You're looking at a trust. This is a way to let your home pass to the next generation. Make sure that they have assets to the money that they need to keep the lights on, to get everything in repair and ready to sell. The trust is for sure the way to go. I had just this morning a consultation that I had. People called us for probate, and we don't do probate yet. We're going to be adding that practice area this year. But it was just a very unfortunate thing where it was mom and stepdad and a child who's still in college, who's had her biological father just pass away, and trying to figure out what her rights are to get the home, to get a business where it has clients signed up and scheduled, to do all these things. And I just see a cascade of problems happening because there was no planning in place, or at least no planning that anybody found. It's just going to take time for them to be able to get access to the home, to any of the accounts, and to run the business. These are things that estate planning really has to address. And particularly with the home, they're gonna might have to find money from somewhere else to keep the lights on, keep the mortgage paid, keep the lawn mowed until all the court processes have gone through. And sometimes that can last up to 6 months. There are significant delays involved. Okay, so a trust is kind of like a red wagon. So imagine that this little girl's got all of her things neatly in the wagon. When you use a trust, there's privacy, there's control, and there's no probate. And and one thing I should mention, because I was actually speaking with a realtor in preparation for this, and she said, well, I always tell them they need it for asset protection. And I thought, oh, well, we need to clarify that if we're talking to realtors, and if that's something that realtors say. A revocable living trust, which is what we're talking about for estate planning purposes, to forego this probate hassle, does not provide any kind of asset protection for the owner. Okay, the person, the grantor who created the trust, is not getting asset protection from a revocable living trust. They can create it for somebody else when they die. When a trust for someone else now becomes irrevocable, that's when asset protection comes in. But when we're talking about a revocable living trust, we are only talking about avoiding probate, and we're talking about having immediate control over the trust assets, especially the home. So a trustee can turn around and sign a contract to sell and liquidate that asset for the next generation. Okay. So toys outside the wagon create problems, and we see this every day. Trusts that are empty, and you might find someone who says, oh, but I have a trust. But if you go and you look at the vesting deed, there it is in their individual name. Well, what does that tell you? It tells you that this home, like these toys outside this wagon, and this sad little girl, isn't she so cute? But she's sad because the home never actually made it into the trust. And we have people see us all the time, and we always want to see their previous estate plan documents. Two things that have happened fairly recently. One was, oh, I have a trust. And I say, well, what's in your trust? What do you mean, what's in my trust? Well, it is it is unfortunately a common practice, not malpractice, to have someone sign off and say, hey, I created a trust. I promise that I understand that I need to fund my trust, or this set of documents does nothing. Okay. People sign that away without any support in getting the trust funded. What results is an empty trust with nothing, a very expensive stack of papers that applies to nothing. Okay. So when you create a trust, but everything's outside of the trust, all those things are going to have to now go through a probate process. And now you have a trust administration for the things that belong in the trust, and a probate process for the stuff that got left out. Okay, so this all has to be done very carefully. So just because someone has a trust, don't assume that the trustee can sign a contract. We've got to look at the deed and see if the probate court has to be everything that has to be involved. They either have to have letters or they need to have trustee control to be able to sign a contract. Okay, so you are on the front line of helping people secure their biggest assets. So here are 10 things that you need to know. And you can kind of be the first one. Sometimes you're the one that has that positive relationship with your clients. You're very relational. A lot of you are realtors because people like you and you like people. You are the ones that have that first connection where you can add some valuable things by maybe issue spotting some things and getting people in the right direction right in the beginning. So, the first thing when a surviving homeowner dies, oh, and by the way, you can interrupt and ask questions now if you would like. I'm fine with it. I'm good to do that on the fly if you would like to. And maybe Kate, if some questions come through, if people are typing in questions, just let me know.
For
And we,
sure, will do. You may get to this, but one question I had as you were speaking a few minutes ago about like if the property is not in their vesting deed, if that homeowner is, or if that person that has the trust is still alive, is it easy for them to add that asset or other assets to their trust? And it's only after they pass that that becomes really messy, or is it a whole process to get things added if they try to do it afterward, like if they try to do it later than vesting?
yeah, we don't want, it's too late when they die to add it. So if it's not in the trust and it's supposed to be in the trust, um, I mean, they could go ahead and do the transaction in their personal name, but here's the problem. They have to promise not to die before closing. Okay. So if we could tell when people were actually going to die, we could time these things really well, but we don't know when that's going to happen. And that's why we encourage clients to keep those assets in the trust for their whole life because it's the most devastating scenario when nobody's anticipating a death and somebody passes. And we had the vehicle to do it. It's like we had a Ferrari and we kept it in the driveway. So what do we do if things are not put into the trust? Well, we have to look at the grantor of the trust. Do they still have capacity? Can they still make decisions? Well, then they can still sign the deed, putting that into a trust, and it's not a problem. As soon as it's recorded, it's done. If they don't have capacity, I hope that their power of attorney is written correctly, and that their attorney, in fact, has been given permission to fund things into the trust. I always make sure our power of attorney can do that. When someone dies, we are not moving more things into the trust. That's when the trust becomes irrevocable. And whatever we've done, that's what it is. So time is really of the essence. Like treating these things that they can be done anytime. I even had a professor that I know that said, "Oh, why are you deeding this, so quickly after the trust is done? You are severing tenancy by the entirety in doing that. These extra creditor protections that married couples get." And I thought, oh my gosh, does he know something I don't know? Sure enough, I go into the our statutes. Tenancy by the entirety is absolutely preserved in North Carolina, even if you transfer to a revocable living trust. There's still going to be the right of survivorship. There's still going to be tenancy by the entirety. But we get all these other beautiful provisions where we get to protect minors and, do all these beautiful things that a trust can do. And it also covers incapacity too. So there's just no drawbacks to getting everything into a trust right away. And everyone should probably check their power of attorney documents to make sure that that's something that is allowed for. Does that answer your question, Kate?
Yes, thank you.
Okay, awesome. All right, so when a surviving homeowner dies with a will, the probate court needs to give permission to sell. Bank funds are often frozen. Delays can take months or years, and some of you have experienced this. Family conflict can create more expense and delays. And it's a public record. Everybody's inheritance is a public record, how much they got of what. And you can even go into the probate court and get a transcription of the dirty laundry being hung out as families are fighting about this. They don't ask you if you're related to them or if you're the attorney on the case. If you look it up, you can request a big long stack of documents. So privacy is really an important thing. Now, with a properly drafted and funded trust, a successor trustee can list the house. Funds from the trust account can be used for repairs. No court approval required. This is all done privately. So it's just a completely different scenario when you have the home already in the trust. Now, does it take a couple little extra steps at closing? It does. My house is in a trust, and I got a home equity loan when I started Rasmussen Law. And it was a couple extra steps. The bank was like, well, we could have done the HELOC in our office, but since you have a trust, now you have to go to a real estate attorney. And I was like, okay, but it hardly cost any, the difference in fees was just negligible, but I was protected the whole time. So really no drawback there. So when the surviving homeowner is incapacitated, if there's no plan in place, the will's not in effect. So if they just have a will, that's not going to help them. There's something called living probate if there hasn't been a plan, which is the person has to be adjudicated incapacitated, and now we have to have a guardian of the estate make those determinations. Accounts are frozen until the guardian is named, and a POA may work or it may bar action depending on how it's drafted. It could be outdated, not state specific, or there could be other reasons like they just don't like it. It can create problems in the POA because these things are kind of all over the place. And we have found your banks and everybody wants a fresh POA, and people don't tend to keep them fresh. So now with a properly drafted and funded trust, incapacity is privately determined. A lot of people don't know this, but you can actually define your own incapacity in your trust. You could have a panel of your three best friends that you talk to every single day. And if they decide that you are off, let's say Annie's three best friends are like, you know what? She's not been herself and she says she's going to buy a boat. Well, they can get together to help protect her. And they're like, Annie doesn't need a yacht this year. And they can have a vote. She's determined incapacitated. And all the plans are in place. We don't have to have the court name anybody because we already decided that her healthcare power of attorney is the guardian of her person in that situation. And her attorney, in fact, under the POA is now the guardian of her estate. Now the guardian of her estate has the power to sign for her in all of her adulting capacities that have to do with money or Netflix or the post office or whatever she needs. And when it comes to managing and selling property, the successor trustee can take care of that even during incapacity. The trust applies, and funds from the trust account can be used to get everything ready. And that's huge because what happens often with estates, and maybe you've experienced this, is things need to be done to get this house ready to sell. And the people don't have the accounts unfrozen, or there's not enough money, or they can't get to all the accounts. So these things can't happen. You might not be able to sell as quickly or for the kind of price that you want. Okay, so just to reiterate, trusts only work if the trust is drafted correctly, set up correctly, the home's deeded into the trust and recorded. And this happens all the time. We see unfunded trust constantly. I literally had some of the most sophisticated clients who came to me and they were like, oh, we have a will, but we would like to do a trust. And in their paperwork was a trust. They had gone to willstrustenestates.com and they must have accidentally checked trusts. And now they had a will and a trust with conflicting provisions and nothing in the trust. Like their estate plan did nothing but hurt them that they created online. So I just can't emphasize this enough. Don't take everybody's word for it, what they say that they have. You need to go verify, go look at the deed, see what they have and see where it is. Okay, so let's talk about, okay, Annie, you have a question.
I just wanted to, I think it goes with exactly what you're talking about. How Deb and I got connected was I have a client and they're looking to sell their mother's home and move her in with them. They have a trust. It's 50-50 with brother and sister, which one wants to sell and one does not want to sell. So that becomes a conflict. The sister had a power of attorney allowing her to do anything with the real estate, but because that home was in the trust, it's no longer part of that power of attorney. So I just thought that's something that goes along with exactly with what you were just saying.
Yeah, and that's a really, thank you so much for bringing that up because it's a really important distinction. Like, what applies to the trust and what applies to the power of attorney? Well, the trust only applies to trust property. And then the power of attorney is literally everything else. And by the way, who drafted that? Where two people have the power to decide. Like you got to think one step ahead and say, but what if they disagree? That should have been written in there. Exactly what happens. Aunt Judy's the tiebreaker. Or the daughter who we like more actually gets two votes. Like whatever it is going to save this family from conflict. But if you understand that what the trust applies to and what the power of attorney applies to, you will understand more than most people. And also understand that when somebody dies, the power of attorney is no longer effective. That's one of the questions I got asked this morning was, well, there's a power of attorney. Can we use that? There's no will, there's no trust, there's no anything. Can the power of attorney keep my father's businesses from shutting down? He's got a great business, but nobody has the authority to do it. Well, no, actually, because the power of attorney ended when the father passed. So, a lot of unintended consequences when people either do it themselves or get estate planning done as an afterthought to some other transaction or do it online. Okay, so best practice for rental properties. Best practice for the property is to put it in LLC. And the main thing that we're concerned about is asset protection. We're not asset protection, but the liability risk associated with a rental property. Just assume that people will sue you if they can. And you probably have the nicest renters. Your clients have the nicest, they would never sue. It's going to be just fine. Well, that's just fine until it's not. But we want to bubble wrap the rental properties in an LLC because we don't want to max out any sort of policy. And all of a sudden, we're reaching into the other assets to get money to settle a lawsuit. It's just unnecessary. So we create the LLC. But the next step is to assign that LLC to a trust. Now, why is that important? Especially for single member LLCs, because we see people just setting up these LLCs. There's no operating agreements or anything, and they're just LLCs all over the place with a different rental property to each thing. Okay, that's fine. An operating agreement would be a lot better, but we need to assign that LLC, your interest in it, to a trust. So I'm just going to use Annie again. Let's say Annie is the owner of an LLC. Well, when we assign it to the trust, we're creating a legal fiction and we're saying, oh, it's not Annie who owns this. It's Annie's avatar, the trustee of the Annie Trust. And we all nod and think, oh yeah, that makes sense. It's obviously not Annie, it's her avatar. But this is the legal fiction we all have to create to allow this trust to move the interest to the next generation. Because if Annie dies, then all of a sudden her interest has to be probated. But if Annie's avatar is holding it, it just goes to the next trustee of the trust. Or if Annie is incapacitated, it goes to the successor trustee of the trust. So that is why we need to have the LLC also assigned to the trust, and the property and the LLC will avoid probate if we've done this correctly. Okay, now second homes are a little bit different because if this is just the home that we're just using for our family and we just go to our beach house, then we're not anticipating anybody suing us. It's probably overkill to have an LLC and you don't want to have to file all that paperwork anyway. We will just assign that to the revocable living trust directly. And that is the best way for this second home to then be in the trust, and let the successor trustee decide what happens to the home. And they have to do it in the benefit, for the benefit of the beneficiaries. But the last thing we want to do, and this is what we see with second homes, they will go to the next generation, and then we have brother and sister not agreeing again about what happens to the home, and they both are the heirs, but now they're married and now their spouses have to sign, and say three of them are on board but somebody's spouse is not on board, won't sign. That goes on too long and they're like, let our kids figure it out. Now they've got 5 kids and 5 more spouses involved, and it just becomes a mess. When you assign it to the trust, a successor trustee can take care of what needs to happen next, whether that stays in the family and you're now going to treat it another way, or if you're just going to sell it. The less people we have deciding this, and the more the person who created the trust can pick who they want to make those decisions, the better. Okay, so legacy property is a little bit different. So we are talking about great grandma's lake house. So we want to manage these through an LLC with clear family rules. So the rules can address things like inheritance, buyouts, decision-making sort of thing. And the family, instead of being on the deed, are now members of the LLC that can pass their interests along to each other, because invariably you're going to have people who want to sell. We don't even go there. We don't live close enough. Blah, blah, blah. They want out. Well, they can get out. And the people that want to stay in can get in, and all the rules are within the LLC. And then the operating agreement of the LLC should allow each person to sign their interest to their revocable living trust. So then we have the same situation where they can now pass their portion of that LLC along without a court probate proceeding. Okay, so here's a bonus slide, and I mentioned this before. Don't do this. Do not allow a property to go to the next generation if no one wants it. You need to explain to people what's going to happen, that they are going to pass an even bigger mess to their children. And maybe this can help you if they are having misgivings about listing something, or there's problems that they can't get through. They need to understand what happens if they do not fix the problem in this generation. The problem increases exponentially with every single generation, because now there's more heirs and more spouses. And often, recently, a couple months ago, actually, I dealt with a property that was back from right after the Civil War, 40 acres and a mule, that had gone, those same 40 acres, from generation to generation to generation. And now we're having to untie, we're having to find heirs, we're having to get guardians for the heirs we can't find. And it's a mess. And this property maybe isn't worth the court battles that it's going to create at this point, which is really sad because it's a really beautiful place. So be a real estate hero. Talk them into selling in this generation. And we don't have, and you need a property law attorney to come and talk about partitions and, all the things that you can do to get that title marketable in this generation, but be the one that figures it out. Being fairly new to the law space, I have learned that if you care enough about that family, it is figure outable. And it's easy to pass the buck on to someone else. You're going to have some easy transactions, but you're also going to find families who absolutely need you to care enough to figure it out, to bring in the right people to help you figure it out. And I hope you do. I want you all to be the real estate heroes. All right, so out of state buyer concerns, a couple things that you're going to see on the front lines. Sometimes people have an estate plan that is under the law of a previous state. So let me just tell you what that might look like. So say, for example, they already have a trust in another state, and now they want to keep, a lot of people move here. Am I wrong? Or do they move here from New York like all the time? Okay. So people move here from New York and they're like, well, we have two rental houses in North Carolina or in New York, and those ones are in LLCs assigned to our trust. We want to keep our trust. And so now we're going to buy a North Carolina property and have it in a trust. Or we have wills that are under the law of another jurisdiction. So the practical effect of that, well, the actual effect of that is in America, any contract made in another state is still in force in this state. So it doesn't mean that they can't use their New York trust in North Carolina. They can, but the practical matter happens that when that thing needs to be administered, now you have lawyers that are straddling the law of two different jurisdictions. So you've got to get a North Carolina lawyer, and now you've got to get a New York lawyer to work together, or you have to pay the extra money for the North Carolina lawyer to figure out how to apply the New York law. Oh, and by the way, if some of the parts of that trust or that will are missing, now they have to go into the law where the person died. Maybe if they died in North Carolina, it's all under that law. And so you can imagine that, lawyers don't mind doing it. Probate lawyers are like, yeah, I'll administer that thing. But the administration cost is going to be through the roof. It is so much cheaper to just go ahead and redo the documents in the new state. You can keep the same law. You can keep the same name of a trust. So we don't even have to mess with the New York properties. It's still going to be called the Rasmussen Family Trust, dated, 1978 or whenever they set it up. We'll still call it that, and we'll deed the property in North Carolina into that. But we're going to restate the whole entire trust now under North Carolina law to match the new jurisdiction. And we're trying to guess where this person's going to die. If they move here and they spend their time in North Carolina, chances are this is where it's going to happen. We're guessing where they're going to be incapacitated if that ever happens. We're guessing North Carolina. And so those documents need to be updated because it will spend so much more money if it's not updated. There is an ancillary probate risk. So what does that mean? Let's say we have properties dotted all over the United States or in any other state, and they're not in a trust. Well, guess what? Probate has to be open in every single place that there is property owned that is not in a trust. So sometimes I had someone recently who they inherited a peat moss farm in Florida. I don't even know what that is or why anyone would want one, but there were now multiple owners of just this little thing, and a whole probate proceeding had to be opened just for that piece of property, ancillary to, or in addition to, where the actual probate proceeding was happening. So it's really important to have an inventory and make sure that all of the properties are held the same way. And as a realtor, as someone who is hopefully not just going to help them buy this house, but you might help them sell this house and buy another house or whatever. We want to make sure that those properties are always being passed in a way that is going to make sense, where they're protected if something happens. The other reason that out of state, this is just another concern, not necessarily like, because, and I'm telling this to you because I know you care about people, that people need a support network. Sometimes I sit down with people and I say, okay, so who could help you? Who could be your executor? Who could be your healthcare power of attorney? Who could be the guardian of your children? And I just see tears. And that makes me so sad because they don't have the support network. I may or may not encourage people to go to church. Like, I don't care what church you go to, but you need a support network. You need to start meeting people. You need to have the back of your neighbors and they need to have you back. So this is just a concern that they have, but really encourage them to get involved in the community so they have someone who can check in on them and know how they're doing and help them with resources. Okay, insurance concerns. If the title changes, insurance needs to be updated. So this is something not a lot of people think about. So for example, if you're going to deed a home to an LLC, which a lot of you have real estate investor clients, the LLC should be the owner of that HUI policy. And I know, because I was a real estate paralegal, what people do, they get it in their own private name and then they wink, wink, a couple months later, they're asking to deed it to the LLC, but they're not necessarily updating the policy. So maybe this is something that you could help remind people. If they deed to the trust, then the trust needs to be added as an additional insured. We saw a lot of that in California fires, where you had insurance companies that weren't willing to pay after homes were put into a trust because the trust was never added as an additional insured on the property. Okay, just let that sit for a second. That is a really, really big red flag. And the next thing is an umbrella policy. We need to add the trust as an additional insured on the umbrella policy so that a trustee can have access to those funds too. Okay, marital status issues. Divorced, and this is kind of like I said, we've got this meeting of family law, estate planning, estate administration, business law, and property law. Like all these things are kind of converging. So divorced spouses are treated in estate plans as if they predeceased in wills, POAs, and healthcare power of attorneys. You should update anyway. You need to update who you trust and who's in charge. And you probably need to make the bench a little deeper if a spouse is out of your plan. Separated spouses, however, if they've named their spouse that they've separated from as a healthcare agent, that is invalid and they'll be treated as if they died and they're not there and will go to the next agent, but the will's still valid. The POA is still invalid. So those need to be done. Those need to be redone right away. And then deed language must be precise when divesting marital rights. Okay. So if you happen to see on the deed and they say, oh, it's fine. My family law attorney helped me to get my husband off the deed. And now I'm on the deed. Let's say they're separated. I just had this happen with a client. All the deed said was the purpose of this deed is to divest a marital interest. And I thought, this is what their family law attorney did to divest a marital interest. Well, I was very glad that I had some background in property law because something was not sitting right. And I thought, is this adequate? Like before I move her home into a trust, I've got to make sure that we've got clear title on this. And I actually reached out to, I don't know if any of you know Laura Martin with Magnolia Title, but she is someone who's been a super great resource to me for years for any title questions that I have. But and she reached out to several other title attorneys and she's like, it's not adequate. Our marital interests in a home are a bundle of rights. It's not just a marital interest. There's this whole bundle of interests. And the language was not adequate to divest those interests. The separation agreement could not be recorded, way too much confidential private information in there. And they had put the free trader in that. And so we needed to record something additional to be able to take care of that problem. So if you say that something is just divesting a marital interest and you are counting on a family law attorney to be like, oh, that's good. Hopefully you're with a very good property attorney who is going to catch that and be like, oh, maybe that's not enough when our marital status has changed. Okay. And it just so happened that I was on the front line with this one. That doesn't usually happen. Normally it's going to be you who's on the front line kind of seeing things like this initially. And you kind of need to watch over. I'll tell you, working as a property paralegal, the the real estate agents that got the best treatment were the ones who were really watching over that file, asking the important questions, and also being nice. Oh, and bring treats. Like that's what everybody likes in the office, just so you know. Okay, and the next part is just very quickly about your real estate business, what to do if something happens to you. There might be something in your brokerage agreement. If you are, some of you are operating as sole proprietors, but if you have an LLC, I've had this conversation with realtors who've been clients and they're like, well, I'm kind of the whole business, but are you? You have contracts, you have branding, you have referrals, you have signage, you have domain names, you have things that you've built up that you might want to protect. An LLC can help kind of these things wind down and can create part of your plan to wind everything down and liquidate. I think that's all we'll say about that. And what about your family? Look at your cute little beneficiary there. So your own estate plan. So titling your own personal assets properly. Do you have adequate insurance? A lot of people with minor children are very kind of out there as far as risk level. I mean, real estate has not been fantastic. I know it's heating up, but do you have adequate insurance? Do you know that somebody's going to be able to take care of your kids? And maybe the person who's best to take care of your kids is not the person with the money. That's where life insurance comes in. Do you have your healthcare directives in place? You need kids protection planning. You need to not just name guardians for your kids in the will, but also outside of the will, also short-term guardianship for just in case you can't make it home tonight. All of these things should be part of your kids protection planning. So, important point, and you can see I've gone over the 10 things because I kept waking up in the middle of the night going, oh, and this. The cheapest plans are the most expensive. That's not a typo. Estate planning is an afterthought to a real estate transaction can lead to expensive probate. Guys, that was literally my job at a property law firm, was to do all the estate plans. It took us about an hour and a half, and these plans were cheap. We could beat the market easily. But the people we landed in probate is also a very long list. So any sort of quick will packages miss the big picture. DIY and online wills and trusts have the highest probate fees. You're going to pay for it so many times over, so many times more than just doing it correctly. Okay, so when should you plan? If you have minor children, if you own a home or a business, if your current plan's more than 5 years old from another state or was created online, or if you experience a probate process and want to avoid it, and now while you have capacity is really important. And I was just going to say a word about legacy. I'm not going to say too much about this, but this is why we do what we do. I used to help people write their stories before I became a lawyer, and so we incorporate legacy into our process. Average beneficiary is going to spend through their inheritance in about 8 months. Okay, I'm serious. They turn into little NFL players or lottery winners. That's how, it doesn't matter how many zeros, it's about 8 months. but it's your memories, your values, your faith, your relationships, your lived experience that are going to make it into the next generation. And this is just a little bit about the legacy that my parents gave me. I have 13 siblings, and I know that's crazy, but the things that they gave me are way more important than my mom is living a very long time. We burned through everything, and now we're supporting her. But these things to me are priceless that my parents gave me. So even if you never had an estate plan, and the default law of North Carolina was what you had, these things passed on to the next generation are everything. Okay. And I can't even remember. Oh, no, this is my challenge to you. Homes and tangible gifts will come and go. Average inheritance in 8 months is gone. And my challenge to you was to write down a list of 5 stories that changed your life and start writing one of them. This is actually more important than anything else that you learned today as your lived experience to the next generation. Okay, and I'm ready for questions. Thanks so much.
Wow, thank you, Deb. That's so much information. Oh, I love the note at the end to write your story. I'm all about that. I think there's so much to absorb, and I'm gonna have to watch this back like 3 times. So I'm
Oh
gonna
no.
kind of open it up for questions for all of you, but I just appreciate all of your knowledge and your openness to sharing. It's obvious it's passion.
Yeah.
Okay. Why don't you go first? You're muted if you're going, Yuka.
Sorry, I
I
didn't
want the
listen.
next person to go.
Yeah, so my question is my husband and I own 2 properties. One is rental and one is the primary residence. And I remember at the beginning you said if owned by a couple, if one passed away, the other one's spouse will inherit it no matter what. My question is we have 2 minor children, and if both of us died, like car accident, whatever, and if we don't put those properties in trust, still needs to go probate. Is that what?
Yeah. Yeah, so it's a good question because because you know that that will go to your heirs. Okay. So say they're just gonna stay living in the house and and they're not wanting to sell it. The deed vests in the heirs, but we haven't decided who the heirs are yet. So the problem really comes when it's time to sell, that now they have to prove that they're the heirs. There's no other heirs. There is no will that gave the house to someone else. And now we just have to tie up all of that stuff to make sure. So on the one hand, we can have it go from generation, 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 nobody does anything, right? But then on the other hand, now when we go to sell, we have to involve the probate court. Better to just involve the probate court right away, but the best scenario is to just have it into a trust so you're covered the whole time. Does that answer your question?
Okay, so would it be best to put those properties in revocable trust at this point, just in case 2 of us die at the same time?
I would, just because I think people are willing to live with different levels of risk. Some people are like, it's fine. I'm only 30. I'm only 40. But truly, we never know. We absolutely don't know what's going to happen. So my rule of thumb is let's think ahead 3 years. Let's think what your family looks like right now, and let's think ahead 3 years. If something happened to one of us or both of us in the next 3 years, what is at risk? Let's just go take care of it. Let's get it into a trust and make sure that your family never has to interact with the court like that as their new part-time job, or someone in the court getting named who doesn't even know your kids, or on and on and on. There's just the number of inconveniences, injustices, and fees associated with probate are just ample reason to make sure everything's buttoned up correctly right now while you're thinking about it.
Okay, sounds good. Thank you. ありがとうございます。
ありがとうございます。
I speak Japanese. I'm Japanese.
また話しましょうね。
Yes, definitely. お願いします。
Oh, that's fun. I'm having the best day ever. Okay, I think Mindy has a question.
So I have a couple questions. When you write up an offer on a house and you pull up the deed and the seller has everything set up in the trust account, when you write their names on the offer, do you have to write all of that out or can you just write their names? Because I feel like it's been done a couple different ways from the past in transactions.
Mm-hmm. So this is a good question, and this is kind of where I you're gonna have to maybe call the property attorney who does it. But generally, when you are just to explain, when a trust isn't really a container, I know I talked about it like a wagon because I think it helps, but a trust is really a relationship. So it's a relationship with a person. So when I have that with Mindy, say you're my trustee, then I'm like, this is Mindy, trustee of the Vowel Family Trust and any amendments thereto. That is the whole name of it. Whenever you can fit the full name on something, put the whole name on it. And so if you're looking at a trust certificate and you say, oh, it says Rasmussen Family Trust, well, maybe that's just for convenience it says that, but it's going to tell you that when you title things or when you're going to deal with trust business, it needs to be the name of the trustee, comma, trustee of the full name of the trust, dated on such a date, and any amendments thereto. You can't go wrong putting the whole darn thing on there. Okay. If you
But
don't
you can get by with
have,
just
what's that?
but you can just put their names only and still get by with it.
No, never just their names, because it's in their capacity as the trustee. Okay, so it's never just them, because that's completely different. They don't have any authority to make that transaction in their personal name if it's in trust, only in their trustee capacity. And you can look at your trust cert, the way mine's written, because I know this is all over the place, but my trust cert will always say, for convenience, some of these words could be left off of the name when we're retitling things or doing trust business. And as long as we can reasonably ascertain that this trustee and this trust is who we're talking about, it's enough. But your trust cert should say that for you to be able to be like, that I can't get everything on this form. We'll leave a couple things off, but the important thing is the name of the trustee as the trustee, at least the last name of the person and the date. And if you can fit in any amendments there too, even better.
Okay. So I have another thing that I just went through because I just sold a property or just closed on a property.
Mm-hmm.
I was representing the seller who had the trust set up. And she felt like it was kind of a bit of a hassle, but she got through it all. But just for future, I guess I would want to kind of warn my sellers that it might be a little bit more of a hassle. Like, for example, her lender, she was trying to buy a house too, and her lender was requiring a lot more extra information. The attorney fee, or the lender did not want it to be like, the lender wanted the attorney, when they closed on the house, to reestablish a trust account. So she had to pay extra to get it reestablished. And then when they got the proceeds check from the house that they were selling, it was in two checks, one for her husband, one for the wife. And then when they went to deposit them at the bank wouldn't let them deposit it. They had to set up new accounts as trust accounts in order to deposit the checks. So it just was like they felt like they were getting a lot of runarounds.
Mm-hmm.
I mean, not that they would have done it any differently, but I guess I learned a lot from it to kind of warn my next people you might have some obstacles.
Yeah. So a lot of these problems, and I'll tell you that, I told you about the unfunded trust. One of the problems with unfunding trust, like maybe they got the house in, but they didn't create a trust account for the trust. So now they get this check and they're like, there's nowhere to put this check. These are all things that happen when people set up a trust somewhere that doesn't help them complete it, doesn't understand how it works. And so a lot of the hassle comes from that. When it's set up correctly, this is smooth. This should happen easily. They should have just got the check in the name of the trust and it was deposited straight to the trust account that was already established. We wouldn't have had to have all these extra steps. So, it's unfortunate that that was a little more work, but if I was going to say that it was always just so easy, part of the problem comes with multiple, you have so many people in a transaction, multiple people not knowing what they're doing or passing along false information. I have literally gone into banks in this community and said, hey, I just want to talk to you guys for a minute and tell you what my clients are experiencing when they came in there. And they were just like, oh my gosh, nobody's ever told us this. We were never trained. And they appreciated the information. And so I am happy to educate whenever I can so people can learn their jobs better. But seriously, we do better for the world and better for society if we will put up with these little headaches and get things set up correctly so the family is not stuck in probate. People work their whole lives to pass things on to the generation. And families are destroyed in this process sometimes. And I really care about that. And any amount of little headache we have to go through to make sure it's all going to happen correctly now is going to save the family in spades later. I still you can tell I'm like trusts all the way. Let's get it done, get it set up right.
I have a question. We have a trust in another state, and we realized not long ago that the trust was never funded.
Okay.
So, in order, we can, you can work with clients to fund it if it's coming from another state, or would you suggest that we do a totally new trust in North Carolina?
I would when you're doing it in a new state, you're going to have to do what's called restating the trust, which is you just create a whole new trust under the same name. But if that trust was never funded, there is no reason to use that same old name that you had before and the old date. The only reason I would ever use that same date is if we have property titled into that or bank accounts already titled into that, I would keep that same date. But since you have to redo the guts of it anyway, and nothing's titled in it, you may as well just do the whole thing again. And it's a super important thing to keep that up to date so it behaves correctly, how you need it to when the time comes. For the new jurisdiction, you should be looking at your estate planning documents again, like I said, every 3 years, just in case something's come up. But if there's nothing in it, I would just redo it in the new state. That's a good question, though.
Thanks a lot.
We have a question in the chat that I'm going to read. Eric, if you're available, I might have you hop on and clarify. But he said he has a question: setting up a trust for an individual and combining it with an inherited irrevocable. There's not like a polished bow on that. So, but that's
Okay.
I don't know.
So I'm wondering, okay, so are we talking about someone is the beneficiary of a irrevocable trust?
It sounds like he inherited an irrevocable trust and he's trying to combine it with a trust for an individual that he needs to set up.
Okay, so I'm not sure if I'm understanding, but I think we have two separate issues here. One is that we need a revocable living trust for estate planning purposes to avoid probate. That's one thing. That's one thing you do with your own property that that you own in your name as you put it in this revocable living trust. It uses your own social security number. You interact with all the property the same way. Now, if someone's given you something from their revocable trust and they died and now that's irrevocable, I would keep that in trust if you can. You've probably got some asset protection with that. And if you don't need access to that money, it's probably locked away so you can't from creditors and things like that. If you have access to the whole thing and you just want to do the best with your investments, sure, open up a brokerage account, liquidate, everything and hold that account in your trust. You can do that. But if there's some asset protection or it's part of an inherited IRA or something like that, I would keep it where it is and not use that money for as long as you don't have to, and work with your CPA on when and how to access those funds in the very best way.
That makes a lot of sense. Eric, feel free to pop it in the chat. I know
Yeah, tell me if that helped.
made sense to me, but Eric put in the chat if you need any clarification. He said he can't unmute at the moment.
Okay.
I know we are past our time a little bit, and I want to respect your time, Deb. Does anyone have any last remaining questions that they want to squeeze in here real quick? Cool. Well, I'll leave it at that. Thank you guys so much for your time, Deb. I really appreciate you. You were highly recommended by Sterling Law, which is how you kind of came into our orbit. But since she's here, I wanted to give kind of a formal shout out and thank you. I meant to include this in my intro, but Annie Clements is one of the main reasons we were able to connect with you. She did a deal with you guys and was working through, what was it, the sell or buy side? It was the buy side, sell side?
It's the sell side. It's the best that I was chatting about earlier.
Yep. And so, you know how we do here at Choice, like your resources or people that we want to know, especially if they really helped you out. And so we just heard amazing things from you and obviously understood that today. It's obvious that you are passionate about what you do and it shows, and have a heart for people, which I think just goes so far on top of knowing your stuff. So thank you for
Thank
your
you so
time.
much, and all the questions I thought were really good questions, and happy to continue the conversation with anyone here that wants to talk more.
Awesome. Well, when this recording goes out, I'll be sure to include your information so you guys can reach out to her directly if you have any questions. Otherwise, thank you to everyone for showing up today and spending time with us and asking questions, just like Deb said. Thank you so much for your time.
Thank you.
Thanks,
Bye,
Deb.
y'all.